In early 2025, President Trump signed a series of executive orders targeting specific law firms, not for committing crimes, not for ethical violations, for representing clients. The firms targeted were some of the most prestigious in the country. Perkins Coie represented the Democratic National Committee and Hillary Clinton's campaign. Jenner and Block represented clients in election-related litigation. WilmerHale, former special counsel Robert Mueller, was a partner there. Sussman Godfrey represented E. Jean Carroll in her defamation case against Trump. The executive orders directed federal agencies to review these firms' security clearances, their government contracts, and their relationships with federal entities. The message was clear: represent disfavored clients and we'll come after your business. The orders used vague language about, quote, weaponization, unquote, of the legal system and protecting the country from firms that allegedly abused legal processes. But look at the actual trigger. These firms represented people and organizations that opposed President Trump. That's it. They did their job, providing legal representation to the quote-unquote wrong clients. These executive orders didn't survive judicial review. In fact, they were struck down unanimously across multiple courts and multiple judges, including judges appointed by both Republican and Democratic presidents. Judge Beryl Howell for the Perkins Coie case. Judge Howell, an Obama appointee, ruled that the executive order targeting Perkins Coie violated multiple constitutional provisions. The First Amendment. The order violated freedom of speech and association by punishing the firm for representing disfavored clients. The Fifth Amendment. The order violated due process, punishing the firm without any finding of wrongdoing. The Sixth Amendment. The order chilled the right to counsel by making lawyers fear retaliation for representing unpopular clients. Judge John Bates for the Jenner and Block case. Judge Bates, a George W. Bush appointee, granted summary judgment for Jenner and Block, meaning he found the constitutional violation so clear that no trial was even needed. He found the executive order was, quote, viewpoint discrimination, unquote, the government punishing a private entity for expressing views through legal representation. The president opposed. Judge Richard Leon for the WilmerHale case. Judge Leon, another George W. Bush appointee, also granted summary judgment. This is notable because Judge Leon has often ruled in favor of Republican administrations, but here he found the constitutional violations undeniable. When judges appointed by presidents of both parties unanimously agree that the action is unconstitutional, that tells you something about how far outside constitutional norms it falls.